Good morning, everybody. My name is Steve Allegrezza. I'm IHFRA's Managing Director, and today I have the very distinct honor of introducing our guest, Mr. Adam Glazer. Adam is a leading lawyer based out of Chicago, and he has served as not just a friend, but a trusted advisor to IHFRA and its members now for a number of years. He's an experienced trial lawyer. His practice focuses on commercial litigation, contract disputes, asset and commission recoveries, and business law. Adam is very well known, has an incredible reputation for his ability to help independent sales professionals recover unpaid and underpaid commission. And today, that's exactly what we're here to discuss. I think we all know within our industry that this is something that happens all too commonly. And I think it's fair to say, most of us enter into agreements with a new manufacturer. It's a handshake deal. We don't fully understand what our rights are and what actions we can take as independent sales professionals. So all of that said, I'm going to turn it over to Adam, and we'll dive right in. Welcome, Adam.
Thank you very much. Very kind introduction. Good morning, everybody. We're going to dive in, as Steve says, and we're going to talk about commissions. Before we do that, I just want to cover a couple of things. They were cleaning the windows right over my shoulder a short while ago, so there may be some clunking going around. I'll try not to let that disturb us. And I have received some questions in advance of the program today. I believe that those questions are answered within the substance of what we're going to talk about. I will also reach out to the reps who submitted the questions to make sure that we did in fact address their points. I'll do that after the webinar today. And if there's time, I certainly hope to be able to take some questions at the end of the program. If those of you who have questions coming in, or if this program raises any further questions, you'll be able to unmute yourself and ask questions at the end, time permitting. So let me do my best to avoid messing this whole thing up here. I'm going to try to share my screen, and I'm hoping that says I'm screen sharing. So can everybody see the screen? Let me just see a nod. Steve, nod your head if you can see it. Okay, great.
We're good.
Okay. All right. So we're going to get started on the subject that's near and dear to all of our hearts. What happens? Well, there are a lot of scenarios that arise, and I'm going to deal with some of those questions as they come up. But you'll see there's going to be a whole lot of issues that we're going to try to cover here best I can on the subject of commission recovery. I think the first question is, why would we even bother? Aren't the odds stacked against us? Let's think of all of the reasons not to do this, not to consider pursuing your commission dollars, even though you've earned them, even though they should have been paid. There's plenty of reasons to say, oh, forget about it. It's not worth it, right? Well, a lot of people think you don't want a reputation. You don't want it to get around that you had a dispute with one of your suppliers. My, of course, response to that is that's a valid concern, but so too is the concern that by not pursuing these dollars, then you become known in the industry as a softy. And if one principal doesn't pay you and the next guy hears about you, maybe he's not going to pay you either. Maybe that you gain some respect by standing up for yourself and standing up for your rights. After all, you're not asking for charity when it comes to commission dollars. You're asking to get paid what you're due. Then you also consider that you don't have a specific term in your agreement. Most of us have oral agreements. There's nothing in there that talks about getting paid post-termination. They've terminated me after all. What right do I have to actually recover commissions after the termination when we don't have a specific deal about that? And we're going to cover that today. There's a concern that of course, the termination was proper. Well, and that's generally true. The contract gives either party the right to terminate. So what you'll see is that we don't typically bring a claim for wrongful termination. What we'll do instead is to bring a claim for breach of the agreement by not commissioning you consistent with the terms. So the fact that they had the right to terminate does not mean that suppliers had the right to withhold commissions. There's always a concern that perhaps if you bring a commission claim that the manufacturer might come back and you might face a counterclaim. and that certainly is a legitimate consideration. So too is the idea that virtually all of the counterclaims, and certainly in my experience, that manufacturers have tried to assert are BS. The counterclaims usually involve having the attorney scour through the terms of a written agreement if you have a written agreement, or go over the terms best that anybody can recall them of the oral agreement, and try to come back and with the idea that the best defense is a good offense, come back to say that the sales rep didn't do everything the sales rep was required to do, and yet they're coming after me for not fully paying the commissions. Counterclaims should not intimidate you. It's just a defensive mechanism. And unless there is some legitimate basis here, such as if you agreed not to represent a competing line, and you in fact had a competing line and the supplier found out about it, and perhaps that competing line was more profitable for you, then you may want to talk to me about the risk of a counterclaim. But that's usually not the case in these circumstances. And of course, we all know they are better funded. It's a truism. No doubt about it. If you bring your claim through an experienced sales rep attorney, there are ways to deal with that. Usually, sales rep attorneys will take these cases on a basis other than a straight hourly basis. I know that we do. We don't charge our shelf rates. So there's certainly ways to try and make this work and to make sure that you have the opportunity to pursue your rightful commission dollars. Besides, oftentimes you're eligible to recover your attorney's fees at the end of the day. We'll talk more about that. So what's an example of all of this, of a situation where a sales rep perhaps didn't necessarily think that he had the strongest case and yet decided to bring it anyhow? Consider poor Bill Stein. Bill was a rep for Malden Mills. He had 40 years experience in the upholstery industry, and Malden Mills wanted to enter the upholstery business in his sales territory. That's pretty much where the parties' agreement on the facts ends. After that, everything is disputed. What happened was the oral contract was entered into. They had a handshake deal like most of you do. A deal was 5% on all sales. That's what Bill Stein's recollection was. That's what Bill's testimony was. He gets 5% on all sales and on reorders, as long as the customers purchase the same styles that he was involved in getting them to purchase in the first place, in placing the original PO, work that he had done. The parties reached no agreement on other details, such as how long the relationship would continue or any kind of termination considerations. Neither party claims that was part of the deal. So that was the terms that Bill Stein testified to at trial. What happened was they entered into the oral contract. Bill sold fabric over the next year to customers, and then of course they liked the fabric and would continue to place reorders for the same goods. Bill was hugely successful. He built up the upholstery business to multi-million dollars in annual sales for Malden Mills. So you all know what happened here.
Yeah.
Right. Exactly. You're all familiar with that phenomenon. Malden Mills, of course, tried to claim that the termination was due to Bill's inadequate penetration of the market. He built it up from nothing to multi-million dollars, and they assert what every manufacturer could always assert against a sales rep claim: he didn't do enough work. He wasn't successful enough. No matter how many millions of dollars he brought in, if only he had used his best efforts, as we had a right to expect, he would have brought in so many millions more. So Bill didn't take this laying down. At trial, he testified that he understood the trade practice to require payment on reorders in the door at time of termination. This is hugely important because we didn't have a written contract, so the court will consider other factors such as the custom and practice in the industry. And Bill understood that he would get reorders. After all, he was responsible for starting that chain into motion. And as the agent who entered into the oral agreement for Malden Mills, they claimed that he lacked the authority to contract for reorder commissions. They said he came in, he had the authority to sign bill on behalf of Malden Mills, but we didn't give him specific authority to agree to pay commissions on reorders. That's what Malden said. This is their version of the case. And then Malden claimed that the contract, which can always be asserted against any oral agreement, it was too vague. We didn't really know what it meant. It didn't have all of the terms. It can't be enforced. So they they looked at the contract as being something that really worked only to their advantage. It wasn't something that Bill Stein could enforce. And then finally, Malden said that Bill couldn't prove that he was responsible for the post-termination reorders. After all, we terminated him. So how do we know that he's out there, that he had any responsibility for this, that he really generated the orders? And then they throw in, and by the way, we paid another rep. So how can we possibly be expected to pay Bill? All right, so at trial, Stein testified that it was the practice that goods would typically be ordered, these fabrics would typically be ordered for 3 years. And Malden Mills was a little concerned that Bill might ask for more than 3 years of post-termination commissions. So they quickly stipulated to the 3-year period. They said, okay, fine, we agree that they're typically ordered for 3 years. Malden's executive came in and said that the trade practice was different. He didn't agree with Bill's version of the trade practice. He said the practice in this industry was only to pay on the sales made and on orders received, but not on reorders. But on cross, the lawyer was able to show that this Malden exec didn't really know what he was talking about, that he didn't have any experience in the industry. And Bill brought in another sales rep to testify that he too had the same arrangement, that Bill wasn't the only one, but that another rep had the same arrangement, and they had also agreed to provide to pay on reorders, that was his understanding as well. So the case went to the jury, and at the end of the day, the court finds that Malden's claim, the defendant's claim that the contract did not include reorders, lacked credibility. They didn't go for that. They said that that the fact that the other rep came in and backed up Bill's claim, and the fact that Malden's witness didn't know what he was talking about, meant that Malden's evidence on this was not going to be seriously considered. The court ruled there was nothing unusual about paying on reorders. This was the practice in the industry, especially in light of the fact that the plaintiff paid all of the costs. That's something all of you can relate to. You're asked to shoulder that burden as well. You pay all the selling costs. So reorders are not uncommon or unusual. And then, of course, if reorders are in play, they are commissionable. And this is the key language here. We're going to talk more about this. Based on the premise, they continue to flow from the original procuring cause. Very important language. They flow from the original procuring cause. We're gonna talk more about that momentarily. So let me tell you, this is just one sales rep who did well for himself. He didn't take it lying down. He asserted his rights, and he got paid what he was due. Consider this, because I receive a number of calls on a regular basis from sales reps. Things happen, and they're all concerned. And probably the most common area that I receive calls in are the following. I've been terminated and have no written contract. Do I have any rights? Adam, I found this customer. I'm the one who brought in this customer. Or they gave me this customer and it was a $1 million line and I grew it to $20 million. And then they terminate me. What about my backlog? They terminated me and I have this huge backlog. And then finally, I haven't been terminated, but they're taking my biggest account as a house account. These are the most common questions. I get lots of other questions too, but I think these are probably the ones that we're going to talk about today. Know in advance that the potential remedies, if we prove that what they've done violates the agreement, we can seek our contract damages, meaning our commissions. We can usually seek exemplary damages, and I'll explain that to you as well. Not just the contract damages, but 2 to 4 times the unpaid commissions. And the same statute will give us the right to recover attorney's fees, costs, and a separate statute enables us to seek interest on the money that they had, even though it was our money, they had the use of it and we didn't. Most of the time you get terminated, you don't know what the sales are. You don't know what happened after termination because you're cut off the system. They no longer send you commission statements if they ever did, and you don't have any ability to determine just how large the sales were. So we can seek to get an accounting from the manufacturer. And then in certain cases, if it's in your interest, we could seek to be reinstated depending on how the termination was handled. That's not as common as seeking the other remedies. All right, so let's move on to the first call. I got terminated. I don't have a contract, Adam. Do I have any rights? So the first thing to consider is you do have a contract. You have an oral contract. You don't have a written agreement, but you have an oral contract. So on termination, we consider a number of different things. Most of these oral contracts are terminable at will. That's a legal term. It means you can be terminated for any reason or for no reason. But as I mentioned before, that doesn't mean they have a right to withhold commissions. We don't typically, as I said, dispute the termination right, but the contract that you have with them may give you a basis. You have to consider what the terms of the oral agreement were, even if they're not documented. Did you discuss any specific termination rights at the time that you made the deal? I know that that's not commonly done, but consider whether you had a situation where they were discussed, whether limitations were agreed upon or rights were discussed upon termination. And maybe there will be some basis to contest the termination, but it's case by case. It depends on your individual situation. You also have to evaluate, of course, how much is owed. And this is a very common question I get. Adam, I have a great case, but I've only got $2,800 in unpaid commissions. Is it worth it? And I'll be candid with you. If you tell me you got $2,800 in unpaid commissions, I will usually suggest to you that you want to take that to small claims court. You don't want to pay an attorney to try and recover it. The clerk at the local courthouse will usually be very helpful if you go down there and file what's called a pro se complaint, meaning you're doing it yourself without an attorney, and decide whether the dollars involved are worth fighting over or whether you should just put this behind you and be grateful that you got screwed out of 2,800 and not $280,000, for example. Consider whether it's just you. Consider whether you got terminated here or whether this is bigger than just you. And maybe they laid off other reps at the same time, maybe all of the other reps at the same time. And if they're not paying you the commissions, potentially it's economical to band together and to work together to get paid. A lot of times there's strength in numbers, and the supplier will look at you much differently if you are part of a larger group that's coming after them. But if it's just you, that's fine too, as long as the amount is not $2,800. Did you accept any restrictions on your post-termination rights? That relates to looking at the contract, but it is a factor. You have to consider whether you gave up any rights, and connected to that is, did you sign anything on your way out? Um, when you were told that you were going to get terminated, did the factory say to you, well, we'll pay you $1,500 for one particular sale, but here, sign this release. So be careful about anything you're asked to sign when you know that termination is looming or that you've already received notice of termination. Now, I said before that you can be terminated for any reason or no reason, and that is a broad category. That means, the regional manager has a brother-in-law who just moved into the territory and he wants to give him the line. You're upset because you never got a fair shot at working the line. They falsely accused you of repping a competitor. You needed to they needed to get to a more competitive price, so they got rid of you for that reason, or they went direct. All of these fit within that category of getting terminated for any reason or for no reason, and that's why we don't typically go after them for the termination. We don't assert a wrongful termination claim. One exception to that rule It's a rare limitation. It involves the duty to work in good faith. And what I mean by that is, while you can be terminated for any reason or no reason, you can't be terminated to avoid a commission obligation. If they know that a customer you called upon has placed or is about to place a very significant order, and they get rid of you just in time to avoid what they think is the commission obligation, that's bad faith. That's a claim that where we can assert you were terminated wrongfully. The house can't also slow shipments, if you have a term that says you get paid upon shipment or upon payment by the customer, they can't delay the shipment so that it comes in beyond the term of your contract rights. I mean, generally speaking, what it means is, since they have discretion here, it has to be exercised reasonably. They can't take steps to avoid your commission payments. You do have at least that much by way of protection. It's not a lot, which is why for the last time we don't typically sue for wrongful termination. But you do have a right to get paid. And as I said, oral contracts are perfectly enforceable. All 50 states will enforce oral contract rights. The elements of the claim are the same. And one consideration is that in many states, it involves a shorter statute of limitations. Um, in Illinois, where I am today in Chicago, we have a statute of limitations of 10 years for written contracts, but only 5 years for oral contracts. So you do have to take into consideration that you may have to move more quickly with oral contracts. But generally speaking, as we always say, an oral contract can be your friend. It's much better to have an oral contract than a bad written contract. Written terms are oftentimes, drafted by the manufacturer, by their lawyers, and they really limit your rights. So oftentimes you can be in a better position with an oral agreement than a form contract that the manufacturer spits out. All right, so we're going to move into the heart of the discussion. Let's talk about really call number two. I found the customer. I grew the relationship. They're terminating me, and now they're going to get the benefit of all of the work that I did, and they're not going to pay me a nickel on those additional sales. Especially with oral contracts, where you did not expressly agree to limit your post termination rights the way you often do in written contracts. You have the right in most jurisdictions to get paid on that post termination business. The legal vehicle for that is known as the procuring cause doctrine. It's a legal it's a common law doctrine, and it says that a party may be entitled to commissions on sales made after termination if that party procured the sales prior to termination. If you were responsible for generating those sales and they continue coming in after termination, or they even start to come in after termination, but based on your pre termination sales efforts, those sales, generally speaking, should remain commissionable to you. When I say it's a common law doctrine, I mean there's no statute that says that that's passed by the legislature. It is something that came up through the court system. It started in the real estate context. The old cases where a real estate broker would show you a house, and you loved the house, but you knew you only had 6 weeks left under your broker agreement. So you delayed buying the house for 7 weeks. Then your contract is up, even though your broker did everything right. You go back to the house seller and you buy the house and you say, now I don't have to pay a commission. But that's not true. The real estate broker, who was ready, willing, and able to close while during the time that he was the broker, and he did everything he was required to do, and he is the procuring cause for showing you that house or that commercial property, he's still entitled to his commission. And I think you can see how that doctrine fits very well in the sales rep context. And we have been bringing it more and more on behalf of sales reps to say that you too should be protected because you did everything right, and you're entitled to get paid because it's your work that leads to those sales. Otherwise, principals could engage in all kinds of opportunistic terminations, much like the house buyer who waits for the contract to end So courts have recognized this doctrine with increasing frequency. The limitation on this is if you have agreed in the contract not to seek post-termination or to limit your post-termination rights. Again, a term usually found in written agreements, if at all, not usually found in an oral agreement. So the door is usually wide open to seeking procuring cause damages based on your pre-termination work. And here's a quote from an appellate court decision in California that basically says, as long as it was your work that led to the sales, even if you didn't personally engage in closing the transaction, and you weren't present when it was entered into, these sales should be commissionable to you. Consider that. You don't have to be there for the closing. You just have to have done your job, been responsible, put the wheels in motion, and in many instances, you've earned your commission, even if the sale takes place post termination. Now, a question I always get asked, both by the sales rep, by the manufacturer, and ultimately by the court is, well, even if you're right about this, Adam, how long? How long do I get commission for? If the customer buys product for the next 30 years, do I get 30 years worth of commissions? The answer is the answer that I always give. I'm not saying there's a firm answer in the law, but the answer that I always give is to say it's for a reasonable time period. There's no quantification of this. If a arm is severed by a defective product, the jury isn't instructed how much the arm is worth. The jury is told to award reasonable damages, and it's up to the injured plaintiff to prove what his damages are by loss of that limb. It's the same concept for a post-termination commission situation, where it's up to the sales rep to prove what a reasonable time period is. If I ask the jury to award 50 years of post-termination commissions, the jury may find that to be unreasonable. If I come in and ask the jury to award 3 to 5 years of post-termination commissions, perhaps that strikes the jury as more reasonable. This is one significant vehicle that we use to get paid, the procuring cause doctrine. Another big vehicle that I believe most of you should be aware of by now, but your factories may not be aware of it, is the availability in most states of sales rep protection statutes. Most states have enacted these laws, not all states. In fact, certain states have, Florida, for example, had a statute and repealed the statute, but most states still have these statutes available, and they are applicable in cases where independent reps have done their job and have not gotten paid. The idea here is that the legislatures know that reps are in an unequal bargaining position, and this is designed to try to level the playing field a little more to incentivize manufacturers not to fall behind or not refuse to pay commissions when they're due. It's not hard to qualify, although most of the statutes vary. There's no uniform statute, so it all depends on what state you're located in, or perhaps what state the contract calls for. Usually it's where the sales rep is selling or where the sales rep is based, but we oftentimes will have options, different states whose statutes we can invoke, and we'll always look for the most favorable state statute, of course. They all cover reps who are due payments upon termination. Some apply even before termination, but all of them at least cover commissions due upon termination. And here's the kicker. These statutes enable the sales rep to get paid not just the amount of unpaid commissions, but exemplary damages, sometimes referred to as punitive damages, but exemplary damages of 2 to 4 times the unpaid commissions. Think about that. You know, you're deprived of $50,000 in commissions that are due, and you're unsure whether that's worth fighting over or not. But when you consider that you're coming from a state that has a very strong statute, and many states have strong statutes, New Jersey has a terrific statute. California has a strong statute. North Carolina. There are a lot of states with very good statutes where you can recover 2 to 4 times the amount of unpaid commissions plus attorney's fees. You get to recover your fees, your costs, and as I mentioned before, prejudgment interest, all because the manufacturer didn't pay in a timely manner. Certain statutes require intentional failure to pay. Certain states make this discretionary about the amount. So they all vary. But this is a tremendous vehicle to use to get paid. Oftentimes, it works better in the form of the demand letter that we will typically send when we educate your supplier for the first time about the existence of a sales rep statute. And then they call their attorney and they find out, oh my God, there really is a statute like that. Sometimes that leads to the negotiations, and this doesn't have to turn into a long drawn out court fight. But it is a weapon that you have available in most states that you should all be aware of. It will help you get paid. Right, moving on. What about my backlog, Adam? What about the money they owe me at the time of termination? The orders haven't shipped yet, but it's a significant backlog, and after all, it's not my fault. It's not, I didn't do anything wrong that the shipments haven't yet taken place. Well, again, if you're in a situation with an oral agreement, it can be very helpful. A written agreement may cause trouble for you if it says that you'll get paid on all shipments prior to termination, but an oral agreement doesn't get that granular ordinarily. So if you have a backlog, again, it takes us to the procuring cause doctrine. If we can prove that you generated those sales, that they resulted from your hard work before termination, they just haven't shipped yet, then under the procuring cause doctrine, we may be able to lay claim to the commissions on those orders, on the backlog. The fourth question involves house accounts. Can they really take it as a house account? You got to start with the terms. So look at the contract. If you have a written contract or an oral contract, go back to what the terms were. Did you agree to any house accounts? Is that part of the deal? If you did not, if the subject never came up and they're taking it as a house account, it's a breach of contract. If house accounts were discussed, did you agree that the manufacturer could convert your accounts to house accounts? If you made such an agreement, then they have the right to do that. If it's an oral or written term, then they can take house accounts. If not, and they take an account, then it's a breach of contract. And then finally, if you did agree that they could convert your accounts to house accounts, did you negotiate that you got anything in return? Was there any consideration that they were required to pay for taking a house account, and was it paid? And if not, it's a breach of contract. So house accounts are every sales rep's nemesis, but again, in the context of oral agreements, these very rarely get discussed. So taking an account as a house account is often problematic for the manufacturer unless they provided some consideration or unless they negotiated with you in exchange for taking the house account. Those are the 4 questions that I typically get, or the most commonly get. Not all the questions I get, but those are what I usually get. And I hope this is helpful in terms of being able to cover some of that with you in advance. So I'm certainly happy to take questions at this point and to discuss any of these matters. If anybody wants to ask the questions right now, let me see if I can get this going again. Okay. Steve, I see you're still with us. Do you want to coordinate that? I don't know what here. I guess you can do it in the
Sure.
chat feature, or you can just raise your hand, and we can call on you.
Yeah, I think that's the easiest way to do it. Either if you want to submit a question in chat, or yeah, I believe you can raise your hand as a participant. I did have a couple of questions. If you don't want, if I can just start.
You're the boss.
Oh, I like the sound of that. So, just generally speaking, and you covered a lot of this, but just as kind of I'm a process guy, right? So, if a rep decides that legal action to try to recover unpaid or underpaid commissions is the right step for them, like where do they begin? What documentation should they try to maintain or prepare? You talked about statutes of limitation, but like, what what do they need to have in order to move forward?
Well, the documents that we typically want to see, well, we start with a written contract, but assuming there is no written contract, then there will typically have been some sort of email notice of termination, something that was received. I mean, it could have been a phone call, of course, but any communication with the house that involves the grounds for termination or even the just the notice of termination that's delivered, we'll want to see all of that. We'll want to know what the run rate was. We'll want to, see what kind of commission dollars we're getting paid. If you received any sort of regular commission reports on a monthly basis when you got your checks, we'd want to see those. And of course, any documentation that you have with either the factory or the customer that would show the quantity of sales that are outstanding and sales that we're going to pursue. Any documentation of that would also be necessary. Now, sometimes the dispute with the house will involve whether or not the sales rep was the procuring cause, because upon termination, the house will always say, we got these sales despite the sales rep, not because of the sales rep, or the sales rep had very little to do with this. We were the ones dealing with the customer. We were the ones making sales calls. The sales rep really just went along for the ride. So any evidence that you have of exchanges with the customer, anything that demonstrates the value that you added to the equation, or that the customer was relying upon your efforts, or had indicated before that you were responsible for the sales, that's all going to be very necessary. And even if we don't have it in writing, I will ask if you know of if you have strong relationships with customers who'd be willing to vouch for you, who would be willing to say, "Oh yeah, we did business. We purchased these products as a result of the fine efforts of the rep, who was exceptionally helpful. We went with this supplier versus a competitor because of the rep." That's oversimplifying, of course, but anything that would help us establish that you were the procuring cause, that you were the reason the customer placed the order, as opposed to any other reason, all of that we would look for, whether it's physical evidence or whether it's you're telling us that these people would be available to support you as needed. That's all going to be very helpful for these claims. Steve, I see that we have a couple of. Let me just see if I can't knock off some of these questions in the chat room. Um, what do you do when you don't get negotiated? You are told there is no discussion. Happens all the time. They give you a contract. They say sign it as is, or we'll get another rep who will. It's a business decision. Oftentimes they will negotiate even though they say they won't. But if you're in a tough situation where they say this is the form contract, every other rep has signed it, you go ahead and sign it, or we'll get a different rep. It's a business decision about whether that's a client that or a account you want to take on, whether that really is a a principle that you want to represent. How long does the procuring cause doctrine last? Okay, well, I think I tried to cover that. There's no uh, rule that provides for a specific period of time. It's a reasonable period of time, and that's how I always argue it to the court. Um, if we're acting for a reasonable period, depending on the product, depending on the relationship, depending on how long it took to get the order, how much you had, how much money you had to spend in that, how much competition there was, whether this was a virgin territory that you took on, whether this was any unusual circumstances, we would all look to obtain the longest period of time, at the end of the case. And in terms of a negotiation, maybe we would want 5 years, but we'd settle for 3. It all depends on how the individual cases go. Okay, Steve, what else do you got?
Yeah, so I hate to even ask this question, but unfortunately, it's all too common right now. With the economy being what it is, there are a lot of scenarios where some of these factories are filing for bankruptcy, but oftentimes, that can leave the rep sort of high and dry. So, are there any legal actions to pursue unpaid commissions if a company files for bankruptcy or decides they want to close their doors?
Yeah, well, those are two different questions. A
Yeah.
bankruptcy is a difficult situation. Uh, you know, all bankruptcies, protect the secured creditors first, as everybody knows. Sales reps are not secured. You file your proof of claim, you move on. If there is a bankruptcy filing, that's generally the case. Um, if the company's going to close the doors, you may have a chance to negotiate with them, because then they're still liable, and maybe they would keep their doors open if you agreed to some sort of installment payments, or if there was an opportunity to work out some other terms. But it's hard to get blood from a stone. So it all depends. You got to be very careful in selecting your business partners, of course. But when things like the pandemic happen, or other very unusual circumstances that affect manufacturers, it's a tough situation, and we can't print money for them. So bankruptcy, going out of business, puts the rep in a very tough spot, no question about it. All right, I'd like to call on some people, but I see there's one more chat question. The question is, can a company charge you back for the freight costs on product that was credited back to the account? You got charged back for the freight when the credit issued. That would be unusual. That's outside the norm in the industry. We would argue that that is a violation of the custom and practice, but it's a contractual issue. If you have a written agreement and it gives them the right to do it in the contract, that comes first, and that would eliminate any question about it. Typically, there's no such agreement on that. And if the company just unilaterally decides to charge you back, the argument we would make is that they had no contractual right to do that. That was not negotiated. That was not accepted when you took on the line, when you shook hands. And that had not happened before. They can't say that they've always done it and you always accepted it. If they just started to do this, you push back. You say, we did never agreed that the freight costs would come out of our commission. That's a typical cost of the manufacturer. We don't get commissioned, after all, on freight charges that are added on to the customer. Why would we get hit with freight costs on the other side of that? So the answer is no, they can't charge you back ordinarily unless it's in the contract. But they're the manufacturer. If you want to keep the relationship because you think this is something that may call it into question, it's a business decision as to whether you can absorb this or whether you think this is worth fighting over. All right, shall we see? I see that Mark Garber is raising his hand. Mark, do you want to unmute yourself? Mark, you're still muted. Try
Can you
again.
hear me? Can you
Now
hear
we
me?
can. Yeah, go ahead.
Would you entertain as a fee a portion of what's collected?
Well, I can talk to you. I mean, I'm not trying to make this a promotional effort for us and how we operate. I can tell you that generally speaking, sales rep lawyers will consider doing these cases on a hybrid basis. That's the norm, as I said at the beginning, and not charge shelf rates. We charge a reduced rate, and we offset that by a percentage of the recovery. So, we don't do it like a PI firm. We don't, we're not PI lawyers. We don't take it on a straight contingency, but we take it on a hybrid or a blended rate that usually makes this very competitive and very affordable for the sales rep as we go forward.
So if I'm located in Illinois, which is what I am, not too far from you, and the firms I represent are out of state, in order to go to small claims court, isn't that still kind of a difficult and costly process?
Well, if the claim is, if you're in small claims, consider that while it's uncomfortable because you don't often go to small claims court. Nobody typically goes there as a plaintiff very often, but it's usually a lot worse for the manufacturer, because the manufacturer can't come in and represent itself. The manufacturer has to hire an attorney, so there's fees associated with the manufacturer. And the small claims courts are usually very heavily weighted toward the plaintiff, toward the claimant against a company. So you will have it's an unusual format, but you usually have a fair shake in a small claims court, but it does take you away from your business, but so too does it take the manufacturer away from its business, in order to fight these cases. It has to be worth it for you. If it's the kind of dollars that aren't even worth pursuing in a small claims action, then you want to just move on. But if you think it's worth fighting over, recognize that it's going to be a pain in the neck for you, but it's going to be at least equally a pain in the neck for the manufacturer.
What's your threshold of coming to you in terms of what you think the uncollected money is? You mentioned 2,800, but what do you think your threshold really is to come to you, to hire you?
Mark, let me suggest that we talk offline, okay? And
Okay.
maybe we can get together and review some of that. Let's
Okay.
try to find I see there are other questions coming in here. Let me see if I can do these from the chat here. Adam stated that certain states are more friendly to sales rep commission issues. Under which state would the litigations occur? The state where the rep lives, the state where the dealer is located, or the state where the company is located? Very good question. Because every statute is different. I mentioned that we usually look for the most favorable statute. And what I mean by that is there's usually language in the sales rep state statutes that says that the action is brought, that the statute is enacted to protect sales reps of our state. And any language in a contract that tries to make the law subject to a different state that would take the rep outside the protection of this statute is null and void. So that means that even if let's say you have a California sales rep who is fighting with a New York manufacturer, the New York manufacturer wants to invoke New York law because it might be more favorable than the California law. And after all, the contract may even say New York law applies to this contract. But because the statute enables the rep to insist on California law, we would invoke California law, which generally is more favorable for sales reps than New York. If we were in a situation that was different, where perhaps the sales rep was a New York sales rep, but the manufacturer is a Texas manufacturer, we might like the Texas law better, so we might go ahead and sue under the Texas sales rep statute rather than the New York sales rep statute. So we would try to find the most friendly sales rep statute for our interests. Not every state has a sales rep statute. If you're let's say, you're a Florida sales rep suing a Delaware company, you're involved in two states with no sales rep statute, so it wouldn't be available to you. Unless we could find another basis. Maybe you were making a lot of sales into Alabama, for example, then maybe we'd be able to use the Alabama statute to help us out. So it all depends on the individual situation. My written contract states that the laws of another state apply in a dispute. Would I have any chance of suing the manufacturer in the state of California where I live? Well, how about that? I think I just answered that question. Okay. And the next question is, I had commissions withheld because of a canceled order. They withheld a 25% restock fee, saying I did not cancel the order after the customer asked. Okay. I was working with the customer regarding their open orders at the time they terminated me. Is it worth it to fight this? Well, that's really the kind of question Mark was asking about. Is the amount worth fighting over? If it's a $15,000 claim, that's a tough one, especially if it's a restock fee. If we're talking about a restock fee, that's not a commission. So you wouldn't get the benefit of the commission protection statutes. It would be a straight action for 15,000 unless there's more here that I haven't heard about. And if it was just for 15,000, you might want to consider a small claims action for something like that. The question is, what if the manufacturer was out of Asia? Very good question. That happens a lot. A lot of Asian companies. It all depends on the company. A lot of times what will happen is the factory will be in Asia, the product is shipped over from Asia, but there may be a US division or a North American division of that Chinese entity. Really, all we need to know is that there are assets in North America, because then if we get a judgment, we can levy against those assets. If this is a strictly Chinese company with no U.S. presence and no assets in the U.S., it's very hard to collect in China. So, or in some of the other Asian countries. So if there is no U.S. presence, it's very difficult. One exception to that is if following your termination, they are continuing to ship product to customers in the US, and the US is sent, those customers are then writing checks or wiring money back to Asia to pay for those products, then there is a revenue stream here. Then we could levy against the customers and get paid from those dollars, the amount of the unpaid commissions or the amount of the judgment that we get, assuming there are enough US customers here who are writing big enough checks. So there is that possibility of recovering. But again, it may start with, what does your contract say? If if there is a written contract, and it talks about, that you have to bring the claim in China or something to that effect, then we may be in more trouble. If it's just an oral agreement, then the question is simply, how do we make service on an entity unless they have a presence in the U.S.? And that's really fact specific. We'd have to look at that more carefully. Okay, I don't see any other. Oh, no, there is one more chat question here. All right, now we're moving into a different topic. Does a non-solicitation clause still apply if I am terminated without cause? I am in California. The rep contract defers to Michigan law. Depends on how the contract is worded. Sometimes there will be language in the contract that will specifically state that certain provisions survive termination, and a non-solicitation would typically be one of those. It may say that that contract survives termination, or the language in the agreement in the non-solicitation clause may have a time period. It may say that the rep is prohibited from soliciting employees or customers of the manufacturer for 6 or 12 or 24 months. Language like that would generally be viewed as applying post-termination. Terminated without cause, as I told you before, doesn't make anything, it's not improper, it doesn't make the contract void. It's only if termination is in bad faith or otherwise violates your rights that then we could argue that if they breach the contract, then you're not required to honor it either. If they didn't pay you the commissions that were due, for example, then we might have an argument that they can't enforce the non-solicitation provision. But if they've paid you everything that's owed and they've otherwise honored the contract, then you might be stuck with that non-solicitation period, again, assuming it's for a reasonable time. They can't tell you not to solicit for 5 years. It has to be a reasonable time period. All right, Steve, maybe we'll do one more of these. It says, I had commission withheld because of a canceled order. They withheld 25 pro. No, I answered that question already. I must have been reading wrong. It says, when we as reps attain a new line, do you provide a service to examine the contract provided by the new company prior to my signing? We do that every day. For the sales reps who are diligent enough to want their contract reviewed rather than just signing it on the spot, that is a big part of our practice. We regularly will review and edit and make suggestions to the contract, assuming you have a supplier who's willing to entertain requests or a little pushback on the form contract. But I recommend that heartily. I certainly think that contracts should be reviewed ahead of time to avoid the kind of problems that I've been talking about today. All right, Steve, do you see any other hands up? Any other questions that we should answer real quick before we sign off?
Not that I can see, but I would remind everybody that one, I believe it was last year you helped us. You provided a draft agreement that any IHFRA member can use when they are entering into a new agreement with a new line. So we do have that available to our members on the website. But then I would also like to remind everybody that if you do have questions that you didn't feel comfortable asking today or didn't get time to ask today, Adam will be at market Saturday, October 14th, in the IHFRA showroom, and you've still got some openings for appointments. And what we'll do is I will share the best way to reach out to Adam to book some time with him while he's at the show. But beyond that, I would just like to, on behalf of everybody, thank you so much, Adam, for sharing your expertise and your insights with everyone today. It always amazes me just how much wisdom and guidance that you that you share, and you certainly enrich my understanding of just the commission recovery process and what's involved and what needs to be prepared. And it makes me feel a little bit encouraged knowing that so many agreements in our industry are based on a handshake. So I'm very grateful for your time. Thank you so much.
Thank you all. Thanks for listening. And I will look forward to seeing some of you at market if you want to get a hold of me. I'm happy to talk to you there.
All right. Again, Adam, thank you so much. I'm going to stop recording, and we are all set. But thank you, everyone, for making some time today. Like I said, we'll have this webinar recorded. We'll put it on the website for you to go back and look at, and I'll send everyone a thank you note for joining today with Adam's contact information. That's also on the screen right now if you want to book some time with him at market.
Steve, could you send all of us a copy of the draft agreement you alluded to?
Yeah, absolutely.
If you could email that to us, that would be great.
I will sure do it.
Thank you.
All right. Thanks so much, everybody. And Adam, thank you so much. Looking forward to seeing you next week.
Me too. See you all then.